Good morning and welcome to the David and David on Real Estate podcast. David Korman, all these round numbers, I'm loving it.
Yeah, that's a good one. And I'm excited for this podcast because we get to talk law a little bit. We're gonna
Oh, I
so
know this one's difficult for me personally. When I saw this decision come through, I didn't know how to take it, David, because the courts have really always consistently ruled that when a buyer defaults, there's really no defense. And I think that this is the first decision that is going to really shake that up a little bit. And I'm curious to get your viewpoint on this. Why don't we give everybody a little bit of a background of what happened?
yeah. Well, we're talking about a recent decision on Van Hoven Drive, and it's not really a buyer default case. I don't really look at it that way because I look at it the other way. It's so what happened here is it should be a relatively standard purchase and sale transaction agreements entered into, and in every agreement there's a time where you're supposed to search title, and there's a date specified in there, and you have to, if you search title, you find a title issue, you're supposed to send a letter to the seller's lawyer. We found a problem on title, we got an issue, and we call that a requisition letter, and you have to send it, and you have to send it by that date in most cases. And then that gives the seller an opportunity to say, no, that's not valid, or if it is valid, it gives them a chance to fix it, and you move towards closing and hopefully fix the issue. So that's what sort of happened here. And then there's, I don't want to make it too complicated, but there's actually, you have to make certain requisitions by that date. But if there's certain issues that go to the root of title, then you're even allowed to make a requisition after that date before closing. So in this case, there was the buyer's lawyer found that there were some outstanding building permits, and requisition, get rid of these permits because it's going to affect the property. And they had until, I should probably look at the actual dates, but I think the agreement was signed in February of the year, and the closing was at the end of March. It doesn't really matter what the specific date is, and they had until like 2 weeks before closing to make their requisitions. And the lawyer did that. The lawyer searched title, made his requisition by the requisition date. So it's about 2 weeks before closing. Hey, found all this stuff, it cleaned it up. What happened is the lawyer wasn't able to get it done because they needed a reinspection. They needed certain things done on the property. They had to get things done. They need the inspector to come back. There wasn't time to get it all fixed and by the closing date. So the seller's lawyer said, hey, we're trying, but we need more time. We agreed to an extension. The buyer says, no, we're not agreeing to extension. We have a closing date. And the seller says, well, I don't have these things cleaned up. I need more time to do it. So either you close and accept them, or we can't close. So the transaction didn't close. The buyer wanted their deposit back and also some damages because the seller couldn't close the transaction, and the seller balked at giving the deposit back and said, no, we acted in good faith. We tried to get it cleaned up. We couldn't. And sold to somebody else, and I think sold for a loss, right? So that's sort of I guess a crude summary of what happened here. Then the question is, should the buyer be entitled to get their money back? Did everybody do what they were supposed to do? So I don't look at it as a buyer default. The buyer refused to close because the buyer didn't want to accept title with those work orders outstanding. Why should they?
Got it. So you're looking at this as a seller default, that the seller can deliver a clean title.
Right.
That makes more sense.
Right. So originally, the judge found in favor of the seller, and then on appeal it was reversed, and the appeal court said, no, that's not right. The buyer doesn't have to close. If the seller, you can't get those issues fixed by title, then basically the agreement gets frustrated. And there's language right in this standard agreement that says if they can't comply with all that, they can't get it done with by the closing date, then basically the agreement's frustrated, it's at an end, and the buyer gets their deposit money, and they're not entitled to damages, but they get their deposit money back without interest, and they're not entitled to damages, which is ultimately what the Court of Appeal decided here. They decided at the end of the day, the buyer didn't have to close, the seller didn't get it fixed. So the buyer's entitled to the deposit money. Actually, they gave them their $50,000 deposit back, but they got it back without interest. And their claim for damages that the seller incurred, because I think they were claiming for $9,000 or $10,000 in damages too, and they dismissed that because there's language right in the agreement says no, if the agreement's at an end because the agreement got frustrated, they just get their deposit back, but they're not entitled to the damages. So that was sort of the bottom line answer that they gave here.
Interesting, because I mean, I know of a number of situations on deals that we were involved with where, there were outstanding permits, and you deal a lot with this on new construction, right? Where you're buying new construction or semi-custom or custom homes where there's still open permits. And the question now is, it's hard to determine by a realtor whether there are open permits when you're listing the property. And now the seller, the onus is on the seller to make sure that all those permits get closed, and they have to get closed in a timely manner. And I know certain permits like landscaping permits or tree permits or pool permits. Sometimes it's time of the year dependent to be able to deal with them. So, for example, if you sell a house in the winter and you have some sort of a landscaping permit or something like that, you can't close in the wintertime. You have to close in the summertime. So, there's certain situations that arise in real estate where it's out of the control of the seller in certain respects, right? So now I guess the onus is that, those situations have to be dealt with very delicately to make sure that the agreements don't get frustrated.
Right. And so I want to just go back to you're 100% right. So they didn't have enough time to fix the problem. Okay. And that's when I look at this, that's the main issue I look at. And I'm just want to, because I've got the language here, they're right in the printed form, agreement of purchase sale. It's in TREB form, it's in the AREA form, that it
Which
provides
section
a
is
group.
it? Which section is it, David?
Oh, it's in
Sorry,
the
I'm
title
giving you
section,
the
whatever the title section
okay.
will be in that. Because it's important, because one of the issues that was raised here is good faith. And we've talked about good faith on many podcasts, the duty to act in good faith, and that the law has been leaning more and more towards that, even though it's very clear, black and white, you follow the agreement's the contract, but the courts have been leaning more to be open to arguments of good faith, that the party act in good faith, the party not act in good faith, things like that. But the language here, because they made a good faith argument, like seller saying, hey, we were trying. We were on top of the inspector. We were trying to get them in. We were close. We got some of it done. We needed a few more days, and we're working. If they just give us an extension for a few more days, we would know to get it done, and then we'd be able to close. So we're acting in good faith. The buyer didn't act in good faith by giving us an extension. Okay. And the court
I mean,
dismissed that.
it's a
Okay. And the
pretty
court
strong
said,
argument, I think.
it is a good argument, but you still have to look at the written language in the agreement. And the agreement says, notwithstanding any intermediate acts or negotiations in respect of such objections, like objections to title, now the agreement shall be at an end, and all monies paid shall be returned without interest or deduction, and seller and listing brokerage, brokerage shall not be liable for any costs or damages. So that's what the court relied on, even though there were intermediate acts and negotiations. The parties were trying to get this issue cleared, and they even tried to negotiate for an extension. It didn't happen. So notwithstanding that there were these good faith efforts, the agreement's still at an end if the buyer chooses it to be at an end, because they don't have to accept bad title or title with defects. But they said you get your deposit, but you're not entitled to damages, because the agreement says you're not entitled to damages in that situation. So, but I'll tell you what my big takeaway from all of this is, David. And I happen to know the lawyer that acted for the buyer. So I don't want to throw him under the bus. He's a good lawyer and he's at a good firm, and they know what they're doing. But they had an agreement that was signed in early February. They had an end of March closing. They had a March, or like it was 10 days or 2 weeks before the closing, to do the requisitions. He requisitioned on that date for these issues. So now they got 2 weeks to get it fixed. Okay. The practice in our office is we got an offer in February 8th, closing in March. We don't wait till March 15th to do our title search and look for problems. We start doing it right away. And the reason for that is because we're always focused on we want the deal to close. If we do find problems, we want to give the seller's lawyer as much time as we can to fix the problem. Okay. Now he could have given him notice, February 15th, and maybe there still wouldn't have been enough time. Maybe it wouldn't have changed the facts. But I like their chances better if they
100%.
if they did it earlier. So the lawyer for the bar didn't do anything wrong. He complied with the agreement. He did his searches. He found the issues. He made valid objections within the time frame that he had to. But at the end of the day, because of what those objections were and the fact there wasn't enough time for anybody to have been able to fix it. So the agreement got frustrated and that gave the buyer the right to get out. Now, I don't know the background story. Maybe the buyer was looking for a way out. Maybe they knew about these things 2 weeks before. They didn't tell the seller because they wanted to give them a short window to try and, we don't know that part of it, right? And we might never know. But that's why, what we do in practice is different than sometimes what our legal obligation are in the agreement. So in our office, we're always trying to do our title search right away, because if we do find a problem, I want to help the lawyer on the other side as much as I can to fix it and clear it up and give them as much time to do it so that we can successfully close.
David, do you think it would be worthwhile to adjust their Schedule B and deal with this situation and override their language in the title clause? Because, I think that, keeping the deal alive and giving a party to negotiate through that situation good faith is not a bad course of action in this sort of outcome.
But change it to say what?
So, I mean, there could be a closing with a significant holdback, or there could be an extension.
Well, that's something that was always open for the parties to negotiate. Okay, but it's really hard to make an agreement acceptable for anybody that says, here's our closing date, but if we can't close on time, we're allowed to extend. We do that sometimes because they build it in markets like we're currently in. Sometimes you can negotiate. Okay, we'll take this closing, but we have the right to accelerate the closing date, or we have a limited right to extend the closing date. So you can do stuff like that. So if they would have had a clause like that in here saying, if the seller, if the buyer positions things that the seller can't comply with in time, then the buyer has the right to unilaterally extend in order to give the seller more time to do it. I don't know how acceptable that would, and I think that gives incentive to the seller side to saying, hey, we don't really have to get this done by our closing date because I really have more time, because if we can't get it done, so why should we kill ourselves? We can't get it done. The buyer's going to extend the closing date. I think we're
That's
better off to have
a
a firm
strong
closing
argument.
date.
What if we do a holdback? What if we say, $100,000 holdback and the closing still has to happen? Um, what if we do a holdback situation? And my subsequent question to you, sorry for putting you on the spot, is would title insurance step in and help the buyer in case a situation arises where now they're forced to close, there's a holdback, but what if the seller can't alleviate the issues? Would title insurance step in and protect the buyer in that situation because now they're aware of it before the actual closing date?
Right. So there's, two questions there to answer. The first one, the holdback. We don't really have a holdback system. So the holdback only works if there's a known issue at the time you're either doing the agreement or sometimes it arises after there's an inspection or something like that. Okay, we did an inspection, we found all these problems, we need the seller to fix A, B, C, D, E, F before closing, and failing which, we're still gonna close, but we're gonna hold back a certain amount of money. You can negotiate that on an amendment or something. Really hard to negotiate any type of holdback on the original agreement of purchase and sale when there hasn't been an issue that's been identified that has to get fixed before closing. So yes to a holdback. Sometimes it can be negotiated when instead of waiving condition, you're negotiating an amendment because you got to deal with the known issues. So that's my position on holdbacks. The second point on title insurance is really interesting, David, because if the buyer's lawyer didn't do those searches with the municipality,
Right.
instead said, we're arranging for title insurance. So we're not making inquiry. We don't know if there's work orders. We don't know if there's anything outstanding. We don't know if there's open permits. We're not even going to look. So now they get a title insurance policy. They close on time based relying on the title insurance policy. And now after closing, they find out that there were these open permits and there were these issues. They would have title insurance coverage to fix up those issues. So they get title and they get title insurance to fix up the problem at under the policy at their expense, which is a reason why on most transactions we don't make these inquiries. Okay, because if you do make the inquiries and find out that there are these issues, work orders, deficiencies, and like that, then you have title insurance won't cover that. You have to
Right.
disclose that to the title insurance company because you might get title insurance for other things, but they will not insure over those known issues. So the only way to get those known issues fixed is for the seller to fix them. And the seller has to be able to fix them before closing. And if they don't, the buyer has the right to get out of the deal. Unless the buyer agrees to accept them or they negotiate at that point for a holdback, till it gets fixed or for an extension to give the seller more time to fix it and then close. But once those issues are identified, it's the seller's obligation to fix it because the title insurance company won't do it. That gets accepted from their title insurance policy. Okay.
So, David, what can realtors do? What can listing agents do specifically during the initial listing process to help sellers get through some of these situations? Especially and like, what are some of the at-risk properties that realtors should really pay attention to?
Well, a lot of times realtors, before you are going to list the property, you go through and you say, okay, we got to do some staging or we got to do some, cosmetic improvements. Sometimes it depends how far that's going to go. Because if you're really doing some serious repairs, you really should fix certain things before we go to market. That's part of your thought process of realtor should be, are any of these things that have to be fixed going to require a permit? Because if so, we got to give time to not only get the permit, get it fixed, get it re-inspected, and make sure that it's closed. So that should be a bit of a red flag. Also, if it's any property that has had a fairly recent renovation to it, where permits would likely have been required, whether it's a demolition permit or a building permit, you got to make those inquiries. Like, how long ago did you do this? Did you have permits? Were they closed? Have you checked to make sure they're closed? So you can so you know that. Now, sometimes, the renovation could have been 20 years ago, and it might have been two owners ago, and you don't know. And nobody knows because the last two owners, when they bought the property, they got title insurance and nobody did a search. And now they sell it, and the new buyer decides, like in this case, hey, we're going to search the municipality to see if there's any outstanding work order. They find one that's 20 years old. So so you can't really protect necessarily for that. But anytime you know that the current homeowner has done something recently, they did an addition, they did a renovation, you should be asking those questions. Okay, because they can look into it before you even put it on the market. Maybe there are open permits and get them closed, get them off the table.
Yeah, no, that's really good advice. And I think if anything, realtors have to pay more attention, especially to the newly constructed homes. And, if a new pool was put in, like look, for those um, areas and ask the questions. And the other thing you can be doing is you can be calling the city and making inquiries and getting something from the city in writing that there's no open permits. Now, David, I know we're running short on time, but I'm just going to caution. I know there was a situation where, one of our agents made an inquiry in a property to see if there's any open permits in the town of Oakville. And a department came back and said, no, there's no open permits. And a different department inside the town actually had an open permit. And that was a really interesting situation because who do you blame in that situation?
Right. Yeah, that's a tougher one. And then how's title insurance gonna figure out that as well? Because what the information that you did have at the time, you gave to that. So normally title insurance, my inclination, they should cover for that. If there was a mistake by the municipality,
I agree.
that's something that
Completely.
title insurance would normally cover for. Because if it was disclosed to the title, we did this inquiry, they came back and said everything's good. Here it is, title insurance. So they're not going to be excluding that because they think it's good. So I'm pretty sure that they should have coverage for that.
I would agree. Yeah.
Okay.
David, thank you so much. This was again a great conversation, and I looked at it a little bit differently, but you're right. There's title issues and that have to be dealt with, and I think it's really important for everybody to know, under what circumstances the buyer has a right to cancel the agreement. So pay attention. I think the industry needs to pay a little bit more attention here, and I think this is a great episode, especially for me, because I was under the impression that there's really not many situations where a buyer has any sort of a defense to not being able to complete an APS. But there are situations clearly where that is the case, and I think we have to pay a little bit more attention as professionals to these title issues.
Right. You have to be aware of it. And the reality is, like, I look at the practicalities too, and 9 out of 10 times with the same fact situations, the parties probably would have negotiated an extension for a couple of days and closed the deal. Because if the buyer still really wanted that property, that's what usually happens. So it's sort of these rare instances when the seller says, "Oh, you know what, this is," or the buyer says, "This is my opportunity to get out of the deal," for whatever reason. And we don't know what that reason. Maybe they found another property. Maybe they just got cold feet. Maybe they just lost their job and they're looking for a reason to not close. But that reason, that valid reason to not close is there. So sometimes, we forget what the legal rights are because more often than not, the parties will find a way to get the transaction closed with a holdback, with an extension, a negotiated position in good faith. But we have to always be aware and be mindful of something. They don't have to, right? So we have to know that there are consequences of not meeting these timely objections.
Awesome, David. Well, this is again a great episode, and I learned something as I always do with these conversations. So thank you so much for taking the time and going over these. And I thoroughly enjoy them because we really get to see in practice what really happens behind the scenes. And when this gets escalated to a higher court, like the Court of Appeals, we know that it was thoroughly reviewed and some really good precedents is being set here.
Yeah.
Thanks so much, everybody. Thanks for tuning in.
Thank you.